Right. These are obviously the breakout sessions. This first session is the Cloud and Data Protection Laws. Laura Irvine is partner and head of regulatory law at Davidson, Chalmers, Stewart, which basically means she is a specialist in data protection. We've just been talking about it. She says she's done about 4 very different presentations in the last week. So God knows where she's going to end up. Laura, over to you.
First of all, I just have to comment on this room. Usually I'm at the other side in the basement in a tiny wee room. So thanks all for signing up, because that lets me be in the big room. And I do like a big room. So, yeah, that's my title. And I am a data protection specialist. So that's where I'm coming from in terms of the legal regulation of cloud and cloud service providers in particular. So it's all about personal data for me, and pretty much I imagine any organisation that's storing information in the cloud is going to include some sort of personal data. So I will give you a little brief rundown on what personal data processing is. These are terms that I use all the time. There's legal definitions. I'm not going to bore you with them, but it's worth reminding ourselves what I am actually talking about. I'm going to talk about the difference between a controller and a processor. So again, these are legal terms defined in the law and very relevant in this sector. I'll then talk a bit about international transfer issues, and this is all fitting into a discussion about contracts. Contracts are not my happy place in law. However, because I am a data protection specialist, it seems to be an area that I am working in more and more. So forgive me for being really dull and talking about contracts. Hopefully it won't be as dull as you might expect. But it's become something that's very relevant to get right in terms of transfers, and obviously transfers between clouds, other servers, and the organisations relying on those. What counts as a data transfer is always quite interesting, and I can talk about that briefly, and then talk about transfer mechanisms and how to make them compliant with data protection law. And then just at the end, if I haven't ranted over my 20 minutes, I will touch a little bit on the reforms that are coming. So we now have the Data Protection and Digital Information number 2 bill. I'll tell you why it's number 2 if I get to that stage in my presentation. And there's a couple of changes there that are relevant to this audience. So here's the law as it is now. Ladies and gentlemen, we still have the GDPR in the UK despite Brexit. And sometimes I still get asked that question, but effectively it just transitioned. So we now have to call it the UK GDPR. It is essentially pretty much substantially the same as the EU GDPR. There's some terms that are different to reflect the fact that it just applies in the UK. We also have a Data Protection Act 2018. That's the bit of law that supplements the GDPR, so it gives us all the added extra stuff that the UK decided upon itself. Also gives the Information Commissioner its powers, deals a bit with law enforcement and immigration data processing. So both these pieces of legislation were changed, adapted slightly when we left the EU, but at the moment everything is pretty much substantially the same. And that has allowed the EU to give the UK an adequacy decision to allow data to still be transferred smoothly without additional safeguards between EU, EEA countries as well, and the UK. And vice versa, the UK is happy for data to be transferred to the EU and EEA countries. So that was a bit of a struggle to get over the line. It happened actually a year after, I think, the official Brexit date, maybe 6 months. And we've got that adequacy decision, hopefully, for the next 5 years. Query whether we will hold on to it. I think we will, but we always have to be aware of the fragility of that, because it would be not very helpful to lose it. definition of personal data. So that's where I wanted to start. Just a quick reminder. What we're talking about is information from which an individual is identified directly or can be identified. So it's not simply names, contact details, anything where you can specifically point to an individual. Sometimes it's information that is in a slightly less direct form, but if your organisation has information that allows you to either name that person or take action against that person, do something to have an impact on that person, that can be personal data. I have a client who deals with smart meters in buildings, and they collect information about what happens in apartments and buildings. So they don't have the names of any of these individuals. They have their location, but they have lots of information about when that individual's there, how much power they're using, how much noise they're making, etc. And that is all personal data, even although they don't actually know the name of the individual. So we've got to think broadly about that. The other thing that's relevant in terms of this presentation is anonymised data. So that's a topic that the Information Commissioner has a consultation out on about the moment. It's an interesting area, as interesting as this gets, but it's an interesting area because actually truly anonymising data, stripping out anything that identifies an individual, can be extremely tricky. And actually, there's almost like a sliding scale of anonymisation. And even although it might actually remotely be maybe possible to identify an individual, once you get down to the bottom of that scale, it is classed as anonymous data. And the beauty of that is that data protection law doesn't apply to anonymised data. So really, we talk about aggregated or statistical information. If that is in the hands of an organisation and they have the ability to link it back to an individual, then that would be pseudonymised data, and therefore the laws apply. But classically, if that statistical information is shared with another organisation, then that's all they've got. It's not personal data. So it becomes much more useful in terms of analysing your business practices and how to get better at them, for example. So we must always bear in mind the kind of anonymous data, and the laws do not apply or don't restrict your use of that in the same way. Right. So in the context of cloud service providers, it's very important to identify the organisation that's the controller of the personal data and an organisation that's a processor of the personal data. And sometimes actually the cloud service provider will be the sub-processor of the personal data. And the reason for that is the controller has all the obligations under data protection law. And the way that you determine whether or not you're a controller is to identify whether you are determining the purposes and means, to some extent, of processing the personal data. And that sounds extremely odd in the abstract, but it all depends on who's making decisions about what data to collect, why, who's got that purpose, what is the reason for collecting that data and doing stuff with that data. And they're the controller. The controller will rely on service providers, other organisations to assist it, to do its stuff. And often, if that other organisation has personal data, it's given personal data by the controller, it is a processor, so a processor of personal data. A processor doesn't have all the same obligations under data protection law. A processor does not need a lawful basis to process personal data. It does it on the authority of the controller. But the processor does have some obligations, the main one being to keep the data secure, but it also now has an obligation to make sure that there's a written contract with the controller, and vice versa. That obligation applies to both organisations. And that written contract has to be legally binding. Super excited about that as a lawyer. And there's lots of different terms that are dictated in the GDPR in terms of what has to go into that legally binding contract. And that is so that the processor does have similar obligations to the controller, not just to keep the data secure, but also to cooperate in terms of access to that data, responding to subject access requests, personal data breaches. You have to have in your contract, the processor will tell the controller immediately, and that's something that interests me considerably at the moment. There's not been, go back, one of the things the GDPR introduced, which wasn't there before, was that processors can now be fined. It was only the controller that could be fined previously. Processor can now be fined, and that's really important because it does have obligations to make sure that things are done properly. Unfortunately, the ICO has not fined any processors to date, and that frustrates me a little bit because it means that the reality of these contracts and making sure that the obligations are there within the contracts, working out who's liable for what in terms of a breach hasn't really been clarified yet. However, Ticketmaster was fined, I think last year or the year before, and Ticketmaster had a chatbot on its web pages, on several web pages. Chatbot was a third party, it was a processor, and it had malware in its system which allowed the baddies to read all the data, all the stuff that was going on the web page, and Ticketmaster had that on their payment page. So baddie malware in the chatbot service were taking all the financial data from Ticketmaster's website. And there's lots of complicated ways that Ticketmaster could have done this better. But essentially, they were fined quite at 1.25 million, I'm going to say, it might have been more, by the ICO. Lots of individuals suing them for compensation because of this breach. But Ticketmaster will be trying to blame the third-party processor here, the chatbot. And they had in their contract, you will not have malware in your system, third-party service provider, funnily enough, and it did. It'll be a wee bit more complicated than that because of the financial information webpage, etc., etc. But that case, it's this civil case where the individuals are suing for compensation. That's due to be heard this year. It won't probably be decided, but it will give us some kind of guidance, and for me, a tool to try and explain to my clients why it's really important to have these contracts in place, because at the moment we have nothing to really base this on apart from the law says so. But if I can, this things like a sales pitch, but if I can say to my clients, well, you'll get fined, so you better put this in place. It's a much easier sale for me, very selfishly, but it's really necessary in terms of making sure that processors take this seriously. Processors will tend to be service providers. In the background, there will tend to be a cloud service provider, so they would be a sub-processor. One of the things that the law tells us is that if the processor has subcontracted the storage of the data to a third party, it has to have an equivalent contract in place with the sub-processor. So that's probably the most relevant place where the cloud service providers come in. And I know there's lots of organisations in here that sit in between all of those services. And that's where it gets really complicated to disentangle who's doing what role. Sometimes a processor can be a controller of certain parts of the data, and there will be a lot of, I deal with quite a lot of clients who are processors, but they actually become controllers because they want to use some of the data to improve their services. They will often make that anonymous, but the process of making the data, the personal data, anonymous is actually processing it so that a controller, even for that very small activity, and then once they got the anonymised data, can they re-identify that because they've got other data? These are questions I don't know the answer to, and if anyone out there does, I'd be really happy to speak to them. But that's the kind of thinking that the lawyers are doing at the moment, and there's lots of jiggery-pokery with contracts about making processors and sub-processors have a relationship with the controller, and it's all very murky, but it's all about this liability and working out who's responsible for what. So it's fun times for lawyers. As fun as it gets, people, as fun as it gets. This is just a small point that I think is probably relevant to this audience. So this controller-processor relationship, the controller gives instructions to the processor. The processor can't decide what to do on its own behalf with that personal data. It just takes instructions from the controller. However, there is a little bit of a fine line there. So that's the quote from the ICO's guidance about processors and controllers. So the processor can, to some extent, decide, you know, what technical stuff to do with the data in order, for example, to keep it secure. And it can do that on its own half without the controller telling it what to do. I find that quite difficult in a kind of pure legal sense. I think it's very practical in that quite often, you know, I'm a law firm. I don't know how to keep my data secure, so I have to rely on my third party to help me with that. And they'll have the knowledge to do that better than me telling them what to do. Fine line, but I just wanted to point that out because it's that when you're trying to differentiate between controller and processor, there are some things that the processor is allowed to take decisions on. I know it's very confusing, and I think, again, there'll probably be clarity at some point. Maybe that Ticketmaster case will help us with that. I've done this slide. I've done this slide as well. So that's, oh, look at that. I've done this. I've done the talking without the slides. I am a genius. Right. So what I then want to talk about is the contractual relationship. So we have contractual relationship between controller and processor and sub-processor. Where is that data? And I often ask my clients this. Where is your data, your personal data? And they'll say, it is in the cloud. And I will say, where is the cloud? And it's not in the sky, as I used to think. It's more and more we will find, particularly post-GDPR, that your cloud is in the EU. And that's still okay for us in the UK because of the adequacy decision. But sometimes it isn't, and that's where we then have to talk about international transfers of personal data. Just finding out where that data is, where the cloud is and where the data should be sitting can be pretty complicated. That's where, you know, looking at terms and conditions drafted by lawyers can get very complicated, and I apologise for that because often it's obfuscated in these terms and conditions. But it's very important because if we are transferring data outside of the safe zone, which would be the EEA at the moment, then it's an international transfer. In the UK, they call it a restricted transfer, and you need to make sure that there's appropriate safeguards in place. And that's not just to get work for lawyers, again, to draft more contracts. It's all about making sure that you and I, as data subjects, are protected. So if our data goes to another jurisdiction, what rights do we have in relation to that data? Would we be able to claim compensation if something went wrong and there was a breach? And also, can law enforcement agencies access that personal data? And these are the very basic fundamental points that are why there's a restriction on international transfers. So we have protections here. It also discourages organisations from simply shipping their data out of the EU and the EEA, and so they don't have to comply with the law. That's why there's these restrictions in place. Again, what counts as a transfer? And it's perhaps a little bit broader than the term implies. So it's sending personal data or making it accessible to a receiver, so another organisation, when the UK GDPR doesn't apply in relation to that processing. So the UK GDPR can apply to other organisations processing personal data in certain circumstances. We'll not go into that at the moment. But essentially, if you're sending it outside the EEA or the UK, then if it's accessible, and that's, I think, sending it, that's what I mean. It's not just sending it physically, obviously, that's not a thing. But if an individual can access that data, not even just download it, access that data, then that counts as a transfer. So you can be using organisations outside the EEA to assist you. They may be accessing your database that's in the EEA, but if they are doing that, that would still count as a transfer. And it has to be sent or accessed by an organisation that's separate from yours. So an employee can actually access data internationally without that counting as an international transfer. And that's something I think that is missed. But if it's another organisation, even if it's part of a group company, accessing data, that counts as the transfer and requires all the additional safeguards. Transit is different from transfer, so if it's just simply moving through another country, that's okay, and you don't need to put in place additional safeguards. These are the additional safeguards. The one that is used most regularly are standard contractual clauses, or we've now, because we have to be different in the UK, we call them international data transfer agreements. And in addition to that, we are also obliged to carry out a transfer risk assessment. The other safeguards there are some don't exist, so there's no codes of conduct or certification yet. Binding corporate rules are for group companies only, public authority agreements, obviously in the public sector. Adequacy regulations, there are certain countries that are good to go, but they are quite restricted. So standard contractual clauses, IDTAs, are the only one that is very useful. There was a recent fine on Meta. I don't know if you noticed that one, how it was billions, I think. And this was the Irish authority, and that was all about Facebook relying on standard contractual clauses for their transfers to the US. And that is not allowed. And also, you put in place the contract, the fun bit for the lawyers, you also have to carry out a risk assessment in relation to that transfer. And that goes back to the risk of us not having our rights in another country, us not being able to claim compensation in another country, and access by law enforcement bodies. And it all comes back, and this, if you ever want to kind of understand it, it's the Schrems II decision, which got rid of Privacy Shield, which was an adequacy decision, a partial adequacy decision in relation to transfers to the US. That was overturned in 2021. It's Schrems II because earlier, I can't remember the year, 2015, 14, Schrems 1 overturned something called Safe Harbour, which was similar. So it is difficult to get that decision in place about transfers to the US. And clearly that's awkward in the tech world because there's lots of tech in the US, I understand. And these transfers really need to have an easier transfer mechanism to make sure we can do this properly, easily, and just in a simple way. There is, at the moment, discussions ongoing between the EU and the US, and they have a proposal, but it keeps getting challenged. And in fact, just as I was drafting these slides, I think on Monday, it was announced, or no, Friday, the data bridge was being created. No detail, it's just a proposal at the moment, but that's the equivalent in the UK, and I think they actually said they'll piggyback on the EU one, because otherwise we would probably be challenged in terms of our adequacy decision, because transfers to the US are the things that Max Schrems, he's the campaigner who takes these challenges. So these transfers to the US are the things that he's most exercised about. And that's the real difficulty. Putting personal data elsewhere puts it at risk. So we, as either the processors or the controllers, have to have those contractual arrangements in place to make sure that the equivalent safeguards are there. We do the risk assessment. If there are odd things happening, dangerous things happening, then we need to take additional steps. And they are very, very cumbersome. Final note then, Data Protection, Digital Information, number 2 bill. So it was resurrected, it was introduced at first, second reading was due to take place in the day Liz Truss was elected. There was other stuff going on, it didn't happen. And then we thought there'd be lots of amendments, there isn't. But there are some changes that will be relevant here. And actually the international transfer test seems to be lowered slightly. So rather than having to have essentially equivalent measures in place, the proposal now is to have measures in place that are not materially lower than the protections that we have in the UK. So we'll see where that goes. We expect it to get over the line before the next general election, although there's a lot of political shenanigans ongoing at the moment that may distract them from that. Right, so that's my whistle-stop tour of legal stuff and the cloud, and I'm happy to take any questions.
Indeed. Anybody got a question? Right at the very front here, please.
Oh, we need a mic.
Thank you. Tommy Irvine, no relation, from Edrington Group. I was just curious about the Meta issue that you mentioned there. Was that in relation to a Meta entity that was within the EU and a Meta entity within the US, and basically them not having an appropriate agreement? And would that, again, in my own organisation's way, we are not basically a UK company, but we have lots of distribution companies which we wholly own. And would just what level of ownership do you have to be where this agreement is
required?
Absolutely required?
Yeah, and that's it's a good question. So yes, Meta obviously in the EU headquartered in Dublin, and that's why it's the Irish regulator that issued the fine, but they had to be told to up the fine. I mean, there's a lot of shenanigans.
Told by whom?
There.
Sorry.
So there's an agreement under the GDPR that they can all interfere to make sure that the fines are equivalent throughout the EU. That was the kind of point of the GDPR. Let's try and get this all to the same level and the same standard. So we don't know the full picture, but the European Data Protection Board issued a notice that said that the fine had to be of this level because all the other countries had agreed it. Ireland obviously has a vested interest in keeping the big tech companies within Dublin for obvious reasons. So there's always been a tension there. And their commissioner maybe hasn't been properly resourced on that basis, etc. Very controversial. But the point of the fine is that it's group companies, so that doesn't exclude you at all from the need to have adequate safeguards in place. So if you're transferring data to another entity, and even if it's within the group, you still have to have adequate safeguards in place. And in this case, Meta didn't. And they
Is that purely because it's international?
Yeah. Yes.
So if there were two Meta entities within Ireland, would they have fallen foul of the same?
No, it was specific. I mean, there's many other rules that Meta would fall foul of, in my opinion. But this fine was specifically to do with transfers to the US. Post-Schrems too, Facebook said they were relying on standard contractual clauses. They would have carried out a risk assessment, but the whole package of safeguards that they had put in place were not adequate. And the problem is, in the US, there's no overarching right to privacy. It's not enshrined in the Constitution. There's state laws. They keep talking about federal law, but they've not got there yet. And particular law enforcement agencies can just scoop up data if they want to, of non-US citizens. US citizens have some protections. And then this right to compensation and to exercise rights just doesn't exist. And the talks that they're having, they keep trying to get it over the line, but there's still a lot of concerns about that, those kind of inadequacies for us as non-US citizens in the US. And it's a really difficult conundrum. I think we'll get there. There'll be a framework, but it will be challenged again. So the solution is just to have all your stuff in the UK, but that's just not practical in a modern, international, global world. So.
I was going to try and sneak in one more question, but sneaky individual there. I managed to get in part B and Z. Oh. So there is. Can we take one more, Pete? Well, take one more right at the back there. Please.
Okay. Thanks, Laura. So it took about 10 years for this 1.2 billion fine to appear. Was it tied back to the Max Schrems gig? Max Schrems originally raised the issue of class action lawsuit for transfer of data, and then that's my first question. And then second question is...
No, you can have one, James. That's it. Sorry, son. Pick one.
I'll go for the second question. Pragmatically, in a model, what's the realistic controls in place? Because actually it's about the use of data, maybe it's not just about the transfer, it's about the use of data. Yeah. So how can we monitor the use of data?
In third countries, in other countries, yeah. So that's the point. The contract, the standard contractual clauses are there, and they're quite involved legal documents. You need a lawyer to help you with them, obviously. But the point of the contract is that there are controls within that dictate quite closely what is happening to the data that's transferred. That's the idea, now I'm sure there's ways to fudge that, but that contract will dictate that. In addition, there are other mechanisms that you can put in place, and it will all depend on the risk that's involved in the data that's being processed. So I don't know what your company does, and come and speak to me afterwards, but Meta, Facebook data, there's loads of really, really risky, kind of dodgy masses of it. Masses, I think it's probably the volume more than anything else that's involved there. If we're talking about health data, we're in the same sort of category, anything criminal justicey as well. But if it's names and addresses and contact details, so, SurveyMonkey and MailChimp, they store data in the US. So I have many, many clients, particularly in the third sector, who use them. And I have to tell them, well, actually, you probably shouldn't be transferring your data. You probably shouldn't be using these third-party software. But actually, if it's only names and email addresses to send out, your newsletters or whatever, I'm not too worried about it. But if it's anything more involved than that, particularly when you're using it for surveys, and if there's anything more risky, then that's where I would say, don't use it. It's impossible to use it. And there has been enforcement action in the EU in relation to the use of SurveyMonkey, I think. So. Yeah, I was thinking of Cambridge Analytica. The class action, yeah. Yeah, well, that was, and that, Facebook were fined because they shared data with Cambridge Analytica and didn't monitor how they were using it. Cambridge Analytica went bust. That was the end of that. So.
Who could have foreseen that happening?
I know.
Anyway, can I ask you to thank Laura one more time, please?